We are
Mr.
live.
Chair. Mr. Chair, we can begin the meeting now if you're ready.
Okay, thank you. The meeting of the Commission on State Mandates will come to order. Welcome to the webinar. Statutes 2022, Chapter 48, signed by Governor Newsom on June 30, 2022, amended the Bagley-Keene Open Meeting Act to extend until July 1, 2023, the authority to hold public meetings through teleconferencing and to make public meetings accessible electronically to all members of the public seeking to observe and to address the state body in order to protect the health and safety of civil servants and the public. The Commission continues to be committed to ensuring that our public meetings are accessible to the public and that the public has the opportunity to observe the meeting and to participate by providing written and verbal comment on Commission matters. Please note that the materials for today's meeting, including the notice, agenda, and witness list, are all available on the Commission's website at www.csm.ca.gov under the Hearings tab. Also, please note that in the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. Please join me in welcoming a new Commission member representing the State Controller, Mr. Sean Silva, Chief Counsel and Deputy State Controller. Mr. Silva has worked for the State Controller's Office as an attorney for over 20 years and served as Commission Counsel for a brief period in 1997 through 1998, where notably he represented the Commission in the City of Richmond v. Commission on State Mandates case. Mr. Silva is replacing member Yvette Stowers, who is now the Executive Director for the Board of Equalization. Welcome to the Commission, Member Silva. In addition, please join me in welcoming back to the Commission, Ms. Jeannie Lee, Chief Counsel, representing the Director of the Governor's Office of Planning and Research. Ms. Lee has returned from her assignment serving on a detail to the White House Council on Environmental Quality in Washington, D.C. Heather, will you please call the roll?
Sure. Chairperson Miller notified the staff that she will not be attending today's meeting and asked that Vice Chair Mr. Walker serve as chair. Mr. Adams.
Here.
Ms. Lee.
Here.
Ms. Nash.
Here.
Ms. Olson.
Here.
Mr. Silva.
Here.
Mr. Walker.
Here. Next is item 1. Are there any objections to or corrections of the May 27, 2022 minutes? Is there any public comment on this item?
Mr. Chairman, I would move the approval of the minutes as submitted.
Thank you, Mr. Adams. Is there a second?
Second.
Thank you, Ms. Nash. There has been a motion to adopt the May 27, 2022 minutes by member Adams and seconded by member Nash. Are you ready for the question or is there further discussion? Heather, please call the roll.
Mr. Adams.
Aye.
Ms. Lee.
Since I wasn't here at the last meeting, I'm going to abstain.
Ms. Nash.
Aye.
Ms. Olson.
I too would like to abstain. I will vote for it if you need my vote to carry it.
Mr. Silva.
I think I present the same problem since I wasn't here last week. I can approve it. I looked at it. I think we're getting tight on the count.
Yes, we do need 4. If you were briefed by your predecessor and the controller, then you also could vote to approve.
I will vote aye.
Mr. Walker.
Aye.
Thank you. Now we will take up public comment for matters not on the agenda today. Please note that the commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Is there any public comment? Hearing no further public comment, we'll move to the next item.
Let's move to the swearing in. Will the parties and witnesses for items 3 and 4 please turn on your video and unmute your microphones? And please rise for the swearing in. Oh, I'm sorry, and please identify yourselves for the record.
Jesse Kirschner.
Oh, sorry. If you want to go ahead. Jesse Kirschner, we didn't hear you.
Jesse Kirschner, Turlock Irrigation District.
Peter Prowse, the claimant's representative.
And Tony Francois also for the claimants on item 3.
Thank you.
And Lisa Kurokawa, State Controller's Office.
Thank you. Do you solemnly swear or affirm that the testimony which you're about to give is true and correct based on your personal knowledge, information, or belief?
I do.
I do.
I do.
Thank you. Please be seated and turn off your video and mute your microphone. Next is a proposed consent calendar. Items 6 and 7 are proposed for consent.
Are there any objections to the proposed consent calendar from the members or from members of the public?
I
there a
would move
motion?
approval. I would move approval of the consent calendar, Mr. Chairman.
I'll second that.
Thank you, Mr. Adams and Ms. Olson. The motion to adopt the proposed consent calendar has been moved by member Adams and seconded by member Olson. Are you ready for the question or is there further discussion? Heather, please call the roll.
Mr. Adams,
Aye.
Ms. Lee,
Aye.
Ms. Nash,
Aye.
Ms. Olson,
Aye.
Mr. Silva,
Aye.
Mr. Walker.
Aye. Motion carried.
Item 2 is reserved for appeals of executive director decisions. There are no appeals to consider for this hearing. Next is item 3. Senior Commission Counsel Eric Feller will please turn on his video and unmute his microphone and present a proposed decision to dismiss the test claim on floodplain restoration condition number 12 of the water quality certification for Turlock Irrigation District and Modesto Irrigation District, Don Pedro Hydroelectric Project and LaGrange Hydroelectric Project. At this time, we invite the parties and witnesses for item 3 to please turn on their video and unmute their microphones.
All right, good morning. Turlock and Modesto Irrigation Districts filed this test claim to seek reimbursement for conditions imposed by the State Water Board for water quality certification under Section 401 of the Federal Clean Water Act to continue to operate and maintain 2 hydroelectric projects. Staff recommends the commission dismiss this test claim and not reach the merits because the claimants are not subject to the tax and spending limitations of Articles 13A and 13B of the California Constitution and ineligible to claim mandate reimbursement. Although Turlock Irrigation Districts claims it levies ad valorem property taxes, the law does not authorize it. Instead, the districts have statutory authority to impose fees, sell bonds, and levy property assessments collected by the county on the property tax bill. Statutes and case law going back more than a century distinguish between taxes that irrigation districts do not collect and assessments that they do. Modesto's irrigation district states on its website that it does not impose taxes, and there is no evidence that the Turlock or Modesto districts have ever adopted an appropriations limit as required by the government code. The claimants want the commission to reach the merits and determine whether they have fee authority sufficient to cover the cost of the alleged mandate. They argue that under Propositions 218 and 26, they have no fee authority since any fees they impose would be considered taxes. But so long as the districts lack statutory authority to impose proceeds of taxes that are not subject to the appropriations limit of Article 13B, the commission lacks authority to hear and determine the test claim on its merits. The staff recommends that the commission adopt the proposed decision to dismiss the test claim and authorize staff to make any technical non-substantive changes to the proposed decision following the hearing.
Thank you, Mr. Feller. Parties and witnesses, please state your names for the record. Mr. Prowse.
Thank you. Peter Prowse, the claimant's representative.
And Tony Francois, also claimant's representative. And we're joined today by Jesse Kirschner, whom will present as a witness during our presentation.
Thank you. Each of you are for Turlock Irrigation District and Modesto Irrigation District. Would you like to begin?
Yes, and just to be clear, Mr. Kirschner, he is the accounting and finance department manager for Turlock Irrigation District, not Modesto Irrigation District. But both Mr. Francois and myself are representing both of the irrigation districts.
Thank you for that clarification.
Can you all hear me okay?
Yes.
Okay, good, thank you. We'll proceed today as expeditiously as we can. I will give some opening remarks. Mr. Francois will address legal points about whether Turlock Irrigation District receives property taxes. He will also conduct a direct examination of Mr. Kirschner, and I will close with some brief remarks. The issue presented in the proposed decision is whether the districts would have to fund the mandate at issue in the test claim here from proceeds of taxes. This proceeding is essentially at a motion to dismiss stage. We were assured over the course of the briefing of this that this was a pure legal question, and yet the proposed decision is loaded up with efforts to make a factual showing with website quotes and interpretations of budget documents that were not part of the test claim, and with efforts to refute the factual showing that we have offered. This proposed dismissal stage is not the time to be weighing the evidence. The fact that you've got conflicting evidence before you should tell the commission that this claim is really not appropriate for dismissal before you get to the merits. But even on its own terms, the proposed decision fundamentally misses the mark because it essentially ignores the relevant law, which is Propositions 218 and 26. So the proposed decision may have made sense 25 years ago before Propositions 218 and 26, but it doesn't make any sense now. Before Propositions 218 and 26, local agencies could evade the constitutional limits on taxation simply by calling their revenues something else, fees, assessments, or charges. But Propositions 218 and 26 changed all that. After Propositions 218 and 26, Article 13C, Section 1E of the California Constitution sets up a presumption that any means of raising revenue, whether it's called a fee, a charge, or a levy, or anything else, is a tax. Quote, as used in this article, tax means any levy, charge, or exaction of any kind imposed by a local government, except the following, and I'll get into the exceptions in a moment. Doesn't matter what it's called. The staff acknowledged that the districts have authority, have fee authority. They say on page 2 of the proposed decision, the claimants only had the authority to levy an assessment on the property and other fees and charges. And their view is that since we have fee and charge authority, we don't have tax authority. Elsewhere, they acknowledge that we actually do have authority to levy special taxes. That's Water Code Section 22078.5. This is all a word game. Assessments and other fees and charges are all presumptively taxes. We meet our burden in the test claim to show that the mandate at issue would be funded by proceeds of taxes simply by showing that the mandate would cost money, because any means of raising revenue to pay for the mandate would presumptively be a tax under Article 13C, Section 1E. And we meet that burden at page 162 of the record, where we put in a cost estimate for the cost of the mandate as of a few years ago is $51 million. The commission has the burden of proving otherwise, and that the districts could fund this $51 million through something other than a charge or fee that Propositions 218 and 26 deems to be a tax. That's Government Code Section 17556D, and the recent Department of Finance versus Commission on State Mandates case, 59 Cal App 5th at page 561. The commission can only meet that burden if it shows, and this is, I'm going to quote Article 13C, Section 1E, that the money raised to fund the mandate is for a, quote, specific benefit conferred or privilege granted directly to the payor that is not provided to those charged. That's paragraph 1. Paragraph 2, if it's a charge imposed for a specific government service or product provided directly to the payor that is not provided to those not charged. And paragraph 7, if it's an assessment and property related fee imposed in accordance with the provisions of Article 13D. On Article 13D, the recent Department of Finance case that I cited earlier recognized that Article 13D, Section 6B, paragraphs 3 through 5 imposes similar limits on assessment authority as Article 13C, Section 1E imposes on the authority to levy fees and other charges. Assessments must fund a, quote, service that is actually used by or immediately available to the owner of the property in question. It can't be for, quote, general governmental services where the service is available to the public at large in substantially the same manner as it is to property owners. The commission, I should note, applied those exceptions in the municipal stormwater and urban runoff discharges test claims 03 TC 04, 03 TC 19, 03 TC 20, 03 TC 21. We cited that in our response to the proposed dismissal. So there's nothing novel about what I'm saying here or what the commission has done in this regard before. But the commission can't meet the burden to establish that the money the districts would have to raise to fund the mandate here would not be a tax. Again, this really is a merits question. It is not something that ought to be resolved at the motion to dismiss stage. We have shown enough to establish, as I mentioned before, that money would have to be raised to pay for the mandate, cost $51 million. We've also established at least a prima facie showing that any fee, assessment, or charge imposed to fund the mandate would have to be a tax under the facts of the mandate here. The mandate is for a floodplain, quote, restoration project in the downstream delta and in riparian areas along the Tuolumne River that are outside the district's boundaries, pages 72 to 73 of the record. These benefits of this restoration project are not for the benefit of the district's customers, therefore the benefit of areas outside the districts, not to mitigate any impacts of the projects going forward, but to remediate past perceived impacts of the project. It's a restoration project. The districts can charge, as the commission proposed decision states, assessments, fees, and other charges to pay for this. But those assessments, fees, or charges would presumptively all be taxes under Proposition 218 and 26. Because the benefits of this project are not intended to benefit the people who would be paying for them. This is paradigmatically a tax and not a fee or charge under Propositions 218 and 26. The test claim should not be dismissed. If it is, just fair warning that I'll be recommending to the claimants that they pursue a writ and seek their attorney fees from the commission under CCP 1021.5. With that, I'll turn it over to Mr. Francois. Oh, yeah.
Thank you for your time this morning, members of the commission, and I'll be fairly brief. The essence of the argument in the proposed dismissal order on the claimant's eligibility boils down to this. The proposed order concedes two really important points. First, that both districts do have special taxing authority. And it also concedes that that special taxing authority, the proceeds of those special taxes are subject to the GAN limit and therefore eligible for reimbursement. And in many ways, this just boils down to those 2 points. So the proposed decision makes 2 arguments for why the commission should ignore the fact that the claimants have special tax authority and that they would be entitled to reimbursement or eligible for reimbursement of new expenditures under that special tax authority. First, the proposed decision argues that it's necessary for eligibility to have property tax authority. Secondly, the proposed decision sort of argues, it's not very clear that this is really the point, that a claimant has to have previously exercised a special tax authority to be eligible for reimbursement of a claim that would require those claimants to exercise their special tax authority for the first time. So at page 36 of the proposed decision, the proposed decision argues that or conceives that the districts have special tax authority and that proceeds of those special taxes would be subject to the appropriations limit. There's a list of cases cited generally in footnotes 32 through 34 of the proposed decision that are argued in the proposed decision to support the proposition that property tax authority is necessary for eligibility. And that's in both in the chart at the beginning of the proposed decision at pages 2 and 4 in the column staff recommendation, and then in the summary of findings at page 9, and again in those footnotes 32 to 34. But importantly, none of those cases say that only property tax expenditures are eligible for subvention under 13B section 6. In fact, Article 13B subsection 8C defines proceeds of taxes to include, without limitation, all tax revenues and all fee revenue that exceeds the constitutional and legal limits on fee revenue. So if Article 13B were, if reimbursement for tax expenditures, expenditure of taxes under Article 13B were limited to property taxes, you would expect to find that limitation there in 13B8C, which defines proceeds of taxes. The text says the opposite, that proceeds of taxes includes all tax revenues, and none of the cases cited by the commission proposed decision limits that provision to simply property tax. And in fact, the entire thrust of Prop 13, Prop 218, and Prop 26 have been to more comprehensively define local government revenue of all kinds as taxes, to make that tax revenue harder to raise and harder to spend, and to increasingly narrow the types of revenue that are not considered taxes. So there's no basis to conclude that the subvention right of local governments in Article 13B6 is limited to the expenditure of property tax. Now, there's also an argument made that claimants are not eligible for subvention under 13B6 unless they're solely supported by proceeds of taxes. And that appears on page 22 and on page 26 of the proposed decision. There are no authorities for that either. None of the cases cited actually stand for the proposition that a claimant must be solely supported by proceeds of taxes. And that would be untenable as a general rule, because almost no local government is solely supported by proceeds of taxes. Cities, counties, fire districts, even some school districts all have variations on user fees. Cities and counties impose development fees. There are non-tax revenues of all kinds in the revenues of just about every local government in California. And so adopting this rule that you're only eligible for subvention if you're solely supported by proceeds of taxes, would immediately render probably every city and county in the state ineligible for subventions. We think that's not the intent of the constitutional provision, and it's a very poor reading of the case law as well. There's also no authority for the proposition that a local government has to have exercised its taxing authority before it files a test claim in order to be eligible. None of the cases support this proposition. Instead, the issue is whether a new expenditure forced by a mandate would be paid for from proceeds of taxes. And that stands to reason because reimbursement is only for new expenditures, and every local government has a mix of tax and non-tax authority and revenue. So the prior exercise of a claimant's taxing power cannot be a condition of eligibility. Rather, the existence of taxing power makes the claimant eligible to seek reimbursement if the mandate would require the expenditure of proceeds of taxes. And the commission should proceed to the merits of that claim at that point in this test claim. I'd also note that the correct way to deal with eligibility at this preliminary stage is to do what the Court of Appeal did with this question in the City of El Monte versus Commission on State Mandates case, which is cited in the proposed decision, I want to say in footnote 34. In that case, in determining whether or not the claimant was eligible, the court simply looked at what type of entity the claimant was. Question there was a school district. Then looked at the list of eligible entities in Article 13B, subdivision 8D, which includes school districts. And that answered the eligibility question. It's not more complex than that. Special districts are also listed in section 8D, and it's conceded that both claimants are special districts. So that's how the commission should look at eligibility as a threshold question. So the dismissals should be rejected on that ground and the merits adjudicated. Mr. Prowse will address the issue that the mandate for which the claimants are litigating this test claim can only be paid for from the proceeds of taxes. But before turning back over to him to conclude with that, I want to put on Mr. Kirschner as a witness for the Turlock Irrigation District on the factual question raised by the proposed decision on whether Turlock Irrigation District receives property taxes. I'll note as basically a showing of proof before presenting Mr. Kirschner that actually all of the evidence in your record is that the funds received by Turlock Irrigation District from Stanislaus and Merced counties are property taxes. There's no evidence in the record to conclude otherwise. The speculations in the proposed decision that propose alternative characterizations of that revenue all actually fail for want of evidence to support them. Okay. So at this point, I'd like to call Mr. Kirschner and ask him a few questions. Mr. Kirschner, can you hear me?
Yes.
Thank you. Can you state and spell your first name for the record, please?
It's Jesse, Jesse.
And your middle name and last name.
Ian, then Kirschner. It's Kirschner.
What are your current title? What is your current title, sir?
I am the Accounting and Finance Department Manager at Turlock Irrigation District.
Okay, thank you. How long have you held that position?
Approximately 2.5 years, a little over.
Okay. What are your general duties in that position?
I overlook pretty much all the district's accounting and finance needs, day-to-day operations, and any kind of bonds that we do, that type of stuff.
Thank you. Do you supervise all of the district's accounting and finance staff?
I do.
Thank you. How long have you been with the district, including this position and your prior positions?
Just shy, it'll be 15 years in September.
Okay, thank you. Can you please tell me what your undergraduate education is?
I graduated from Chico State in 1999 with degrees in accounting and management information systems.
And are you a CPA licensee?
I am.
What year did you pass the CPA exam?
I got my license in 2005.
Okay. And what continuing education requirements do you comply with for your CPA license?
We have to comply with, we have to get 80 hours of CPE every 2 years.
Yeah, thank you. Before going to work at the Turlock Irrigation District, what was your professional experience after you graduated from college?
I worked at PricewaterhouseCoopers for about 7 years. And then I worked for a real estate developer for about 10 months. And then I've been at the district ever since.
Thank you. So in your capacity as the finance and accounting department manager, are you familiar with the districts, with Turlock Irrigation District's sources of revenue?
Yes.
Does the district collect its revenues for water and electric service directly from its customers?
Yes.
Does the district collect any of its water or electric service charges through either Stanislaus or Merced County?
Can you repeat the question? I'm sorry.
Sure, let me rephrase that. Do Stanislaus or Merced counties collect any of your water or electric revenue for you?
No, no.
Okay. Are there other sources of revenue besides those water and electric charges?
Yes.
Okay. Is one of those property tax disbursements from Stanislaus and Merced counties?
Yes.
Okay. I'm going to ask, is it possible to do a screen share or can we just refer to documents that we've submitted? We've just got a couple of pages.
Hi, no, the commission will share the document for you. We don't allow people outside of the commission to share things on the screen at commission meetings. That's why we
Okay.
asked for you to submit it before, but you did submit it before, so we can ask our IT person to do that right now.
Let me get my right page.
Okay, let me give a moment here.
Here it is, page 4 and 5.
All right, so
Exhibit
I
B.
need the text back. No,
Which, oh, you want this one?
no, I need the word.
Oh, I'm sorry.
You're asking for the late filing that you filed last night?
No, I apologize. We're trying to figure out our tech here on this end, but we've got it sorted. Mr. Kirschner, the first item I'll ask you, or first document, if you have with you, is the declaration you signed on April 15th. Do you have that with you?
I do.
Okay.
You need to pick it. Okay. There you go.
Okay, sorry for the delay. So for the commission members, this is Exhibit 2 to the claimant's April 18th comment letter. It's also page 275 in the PDF compilation of the commission's exhibits. Mr. Kirschner, is this a declaration that you signed in support of this claim?
Yes.
And could you summarize the amounts of revenue received from Stanislaus and Merced County as property tax as reflected in the declaration, please?
Would you like me to read through all the years?
If you want to just give what the most current complete year's revenue is.
Okay, so for 2021, we received approximately 2.2 million from the Stanislaus County, and then approximately 51,000 from Merced County for calendar year 2021.
Okay, and is your declaration of those numbers here based on your review of the district's records?
Yes.
And as to the best of your ability as the department manager, these are accurate?
Yes.
Very good. Next, I want to turn your attention to a copy of a disbursement check from Stanislaus County to Turlock Irrigation District and an accompanying expenditure voucher. And for the commission members, these are Exhibit 3 to the claimant's May 12th comment letter. They're also pages 285 and 86 of the PDF packet for the commission's exhibits. Mr. Kirschner, do you have those? It's a check and then a spreadsheet.
Yes, I do.
Okay. Is the first page of that a copy of a check that the district received from Stanislaus County?
Yes.
And then is the second page, did the second page, which is kind of a spreadsheet format, did that accompany that check?
Yes.
Okay. So I want to turn your attention to the second page, which is the spreadsheet. And please just read briefly the line items that reflect credits to the district, what the descriptions are, not the money, not the money amounts, but just the descriptions.
Okay. Current secured taxes, current unsecured taxes, delinquent unsecured taxes. Sorry,
Let me interrupt you briefly. Just read the lines that have credits to the district in them, not the ones that are zero.
Right, okay. The next line is unitary. SB 8113 supplemental taxes. FHA in lieu of taxes. And then we have a negative amount for the property tax administration fee.
And so just to clarify, that last item you read shows a deduction from, does the last item you read show a deduction from the total amount to be paid to the district to reflect a charge to the district for the county's property tax administration?
Correct. Correct.
Okay.
That's my understanding, yes.
And so based on your position as the department manager, any communications you've had with Stanislaus County and your experience as a CPA, where this document describes this remittance to the district as taxes, is it your understanding that this is all taxes?
Yes, yes. Any kind of correspondence always comes from the property tax administration for the county.
Okay. And then just to close the loop on this, are any of the funds that you receive from the county on this expenditure voucher for services that the district provides to its customers?
Not that I'm aware of, no.
Okay, thank you. Let's see if I have any remaining questions about that. I don't. The next thing I want to ask you about is the district's budget. The proposed decision claims that the district's budget does not reflect these receipts from the county as taxes. Is there some place in the district's budget that reflects the receipt of these tax revenues from the county?
Yes, it's included in our water revenue line item within our budget.
Okay. So are there other items in that line item?
There are.
Okay. So that line item wouldn't match the tax revenue, but it includes it.
That's correct.
Okay, thank you. And final question, does the district report this property tax revenue to the state controller?
We do, as part of our, I'm going to forget the name of it, our financial transaction report, I believe is what it's called. So we do that annually. It's just one line item within that report, though.
Okay, thank you. That's all the questions I have for Mr. Kirschner.
Thank you, Mr. Kirschner. I'll just conclude our presentation by saying that if the commission can come up with a way for the districts to fund this mandate without fees or charges or assessments that wouldn't be taxes as defined by Propositions 218 and 26, we're all ears. But we haven't heard a way. To dismiss this test claim, certainly you'd need to come up with a way for us to do so. But you can't, because the mandate is not for the benefit of the district's ratepayers, but for the express benefits of other parts of the state. Paying for that would require a tax. TID, at least, Turlock Irrigation District, also receives other property taxes, as you've just heard. This test claim shouldn't be dismissed. It should proceed to the merits without further delay. So that's the conclusion of our presentation. Thank you.
Thank you. Is there any public comment on this item? Are there any questions from members? Is there a motion? Okay, I move to adopt staff's recommendation. Is there a second?
I will second that.
Thank you, Ms. Nash. It has been moved by, there's been a motion to adopt staff's recommendation. It has been moved by Member Walker and seconded by Member Nash. Are you ready for the question, or is there further discussion? Heather, please call the roll.
Mr. Adams,
Aye.
Ms. Lee,
Aye.
Ms. Nash,
Aye.
Ms. Olson,
Aye.
Mr. Silva,
Aye.
Mr. Walker.
Aye.
Thank you.
Motion carried. Thank you, gentlemen.
Thank you.
Thank you.
Thank you.
We will now ask presenters for item 3 to please turn off their video and mute their microphones. And next is item 4. Senior Commission Counsel Elizabeth McGinnis will please turn on her video and unmute her microphone and present a proposed decision on an incorrect reduction claim on municipal stormwater and urban runoff damage discharges. The claimant representative contacted us and said to thank the commission staff for their work on this matter and that they are resting on their written comments. At this time, we invite the parties and witnesses for item 4 to please turn on their video and unmute their microphones.
Hi, good morning. This incorrect reduction claim alleges that the State Controller's Office incorrectly reduced reimbursement claims filed by the City of Lakewood for costs arising from the Municipal Stormwater and Urban Runoff Discharges Program. Staff finds that the Controller's reduction of costs claimed for twice weekly trash collection based on the claimant's failure to provide contemporaneous source documents is incorrect as a matter of law. The parameters and guidelines do not require contemporaneous source documentation for ongoing maintenance activities, including trash collection, under the reasonable reimbursement methodology. Rather, the claimant was required to retain documentation showing the number of trash receptacles in the jurisdiction and the number of trash collections. Nonetheless, the documents provided by the claimant contain inconsistencies and do not verify that trash collection was performed twice a week during the audit period. Staff therefore recommends that the commission remand the claims back to the controller for further review and verification. Staff also finds that the controller's reduction, based on its determination that Proposition A local return funds are offsetting revenues that should have been identified and deducted from the reimbursement claims, is correct as a matter of law. Thus, staff recommends that the commission adopt the proposed decision and partially approve this IRC. Thank you.
Thank you, Ms. McGinnis. Parties and witnesses, please state your names for the record.
Lisa Kurokawa.
Ms. Kurokawa, for the State Controller's Office, do you have any questions, any comments? I'm sorry.
Yeah, I just want to say that we agree with the commission's proposed decision, and we will work with the City of Lakewood to reinstate the cost that you guys have deemed to be eligible for the twice weekly pickups.
Thank you. Is there any public comment on this item? Are there any questions from members?
Mr. Chair, I move adoption of staff recommendation.
Thank you, Ms. Olson. Is there a second?
I would make a second, Mr. Chairman.
Thank you, Mr. Adams. There has been a motion to adopt staff's recommendation. And it's been moved by Member Olson and seconded by Member Adams. Are you ready for the question, or is there further discussion? Heather, please call the roll.
Mr. Adams,
Aye.
Ms. Lee,
Aye.
Ms. Nash,
Aye.
Ms. Olson, Mr.
Aye.
Oh, sorry, sorry, Mr. Silva,
Aye.
Mr. Walker.
Aye. Motion carried.
Thank you. Well, the parties and witnesses for item 4, please turn off your videos and mute your microphones. Item 5 is reserved for county applications for finding of significant financial distress, or SB 1033 applications. No SB 1033 applications have been filed. Items 6 and 7 were on consent, and program analyst Jill McGee will please turn on her video and microphone and present item 8, the legislative update.
Good morning. The following are the legislative updates since the last time the commission met. First, SB 189, state government. This budget trailer bill signed by Governor Newsom on June 30th, 2022, amends the Bagley-Keene Open Meeting Act to extend the authority to conduct public meetings remotely through July 1st, 2023. As relevant to the commission, this bill authorizes a state body to hold public meetings through teleconferencing and to make public meetings accessible electronically to all members of the public seeking to observe and to address the state body. It also suspends and no longer requires the following: the physical presence of members as a condition of participation in or quorum for a public meeting, the identification of each teleconference location from which a member will be participating, the posting of the notice and agenda at each teleconference location, and the ability of the public to address the state body at each teleconference location. Next, AB 1610, state mandates claims, proposed to reduce the minimum amount of costs incurred to file a mandate reimbursement claim. However, it did not make it out of its house of origin before the deadline to do so for this session. Therefore, this bill is dead. Next, AB 1733, state bodies, open meetings. As was detailed in the legislative update for today's agenda, this bill would have made changes to the Bagley-Keene Open Meeting Act. However, it did not make it out of its house of origin before the deadline to do so for this session. Therefore, this bill is dead. Next, AB 1795, open meetings, remote participation. This bill would have addressed provisions for both in-person and remote meetings. However, it did not make it out of its house of origin before the deadline. Therefore, this bill is also dead. Finally, AB 2066, communication, telegraph corporations, telegraphy, and telegrams. This bill would have amended provisions under Bagley-Keene by removing the telegram as a means to waive notice. However, it too did not make it out of its house of origin and is also dead. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you. Thank you for that report, Ms. McGee.
Chief Legal Counsel Camille Shelton will please turn on her video and microphone and present item 9, the Chief Legal Counsel report.
Good morning, everyone. Since our last hearing, we don't have any new filings and no recent decisions. On June 8th, the California Supreme Court did conduct oral argument in Coast Community College District, and we are still waiting for that decision to come. And I don't have anything further.
Item 10 is the Executive Director report. As I'm sure you're all aware, the state adopted a timely budget and the commission's, but you might not know that the commission's budget was approved as proposed with the addition of appropriation to fund the vote by mail ballots, prepaid postage, mandate at the high end of the range of the statewide cost estimate that was adopted by the commission at its March 25th, 2022 meeting. The commission's budget also includes 3 new administrative positions, an information technology specialist 1 at AGPA HR and an AGPA procurement, and also included a reclassification of our current information technology specialist 1 to a information technology specialist 2. The commission management is currently recruiting for and reclassifying these critical positions. In addition, the commission's budget analyst, Katie Lovell, has taken a position with the Department of Healthcare Access and Information, and her last day with the commission will be August 5th. So we will also be recruiting for that position. For workload, after this hearing, there are 39 pending test claims, 37 of which are regarding stormwater. There is also 1 amendment to parameters and guidelines and 2 statewide cost estimates pending. On an active status pending the outcome of litigation, there is 1 parameters and guidelines regarding stormwater. And finally, we have 2 remaining IRCs pending. Commission staff expects to complete all of the currently pending test claims and IRCs by approximately the September 26, 2025 meeting, depending on staffing and other workload. However, some of the pending matters may be heard and decided earlier than currently indicated if they're consolidated for hearing. And that's all I have.
Thank you, Ms. Halsey. Okay, we'll meet in closed session, closed executive session pursuant to Government Code Section 11126, Subdivision E, to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda. And to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126, Subdivision A1. We'll reconvene in open session in approximately 15 minutes. Okay, you can go ahead and log out here and log on using your closed session link. Is everyone here? Like, let me see.
Not yet. We're still missing a couple of members.
Thank you, Heather.
Mr. Chair, I don't know if the members are having a hard time getting in, but we do have a quorum.
Okay, thank you. The commission met in closed executive session pursuant to Government Code Section 11126 subdivision E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126 subdivision A1. With no further business to discuss, I will entertain a motion to adjourn.
So moved.
Second.
Thank you, Ms. Nash and Ms. Olson. There's been a motion to adjourn. It has been moved by Member Nash and seconded by Member Olson to adjourn this meeting. Heather, please call the roll.
Mr. Adams,
Aye.
Ms. Lee,
Aye.
Ms. Nash,
Aye.
Ms. Olson,
Aye.
Mr. Silva is absent. Mr. Walker,
Aye. The motion carried. This meeting is adjourned. Everyone have a wonderful weekend. I'll see you the
Thank
next
you.
time. Thank you.
Take care, everybody.
Take care.